Employees have the right not to be unfairly dismissed. This means that an employer cannot dismiss an employee without a fair reason for doing so. And there are a number of them, in fact there are 5. But some examples of fair reasons include things like poor performance, or redundancy, or misconduct. In order for a dismissal to be fair, the employer must also follow a fair process. And this includes things like ensuring that a proper investigation is followed, holding a disciplinary hearing, or giving the employee the opportunity to appeal. Subject to various thresholds and rules, and then exceptions to those rules, if an employee believes that they have been unfairly dismissed, they do have the right to bring an unfair dismissal claim in an employment tribunal. To be successful in an unfair dismissal claim, the employee must show that the dismissal was not a fair reason and/or that the process itself was not fair either. If a claim is successful, the employee is awarded compensation, and that typically includes lost wages and/or pension contributions. It can also include things like loss of statutory right, for example. But essentially it's broken down into something called a basic award and a compensatory award. It's important to note that there are time limits to bring an unfair dismissal claim, and generally, where the claim has not been brought within 3 months minus a day from the date of dismissal, it's likely to be out of time. So if you do believe that you have been unfairly dismissed, again, there are exceptions to those time limits, but essentially those are the time limits that we need to be working within. It's really important that you take independent legal advice as soon as possible. So do get in touch if you or someone you know may be a victim of unfair dismissal. Details are on the screen.